I'm Simon Holmes, and in my capacity as a visiting professor at Oxford University, I was today presenting a paper which I co-wrote with Michel Miga called A Sustainable Future: How Can Control of Monopoly Power Play a Part? I'm concerned that we too often, as human beings even, we segment our lives between our concerns about climate change, corporate power, and our work. We think we know about the climate crisis, but we forget that when we dive into what I call a competition bubble. And I ask myself this question: if in X years' time our grandchildren were to ask us why we didn't do this or that to fight climate change, and we answer because of some technicality and some long lost, forgotten regulation, we're not going to look too clever. I'm not suggesting for a moment that we don't apply the law, but what I am saying is that we should make the right choices consistent with the law. And if we can't make the right choices consistent with the law, we should have an open mind to changing those laws. And in that spirit, we look in the paper at the increase in corporate power and the growing evidence that this is causing society. Just one example being the so-called externalities, such as dumping effluent into rivers or emitting greenhouse gases. And the two tools which we explore are abuse of dominance and merger control. Now today we were focusing on the latter because this is a merger control conference. Merger control gives us the potential to deal with these problems before they get any worse. I think today I focused on 3 points. The first is what I call the stop and think point. And this is, for example, to think about the scale of the problem. And I saw that Zephyr Teachout, an eminent academic in this area, has said that we've had more than 500,000 mergers in the last decade or so. Not necessarily a problem, but it's part of the perspective. Secondly, the scant evidence of mergers having benefits, and we cite the academic evidence for that. And thirdly, the sheer scale of the under-enforcement, and in particular we focus on that being the conclusion of an IMF paper recently. Secondly, we look at the current tools. What can we do under the current law? We can look at sustainability as part of the substantive assessment. We can take it into account as an efficiency. We can look at remedies, for example, allowing a merger which is positive, has efficiency enhancing benefits, but deal with the harms through the remedies. We look at national competition law, and finally we look at the tools available outside competition law, such as foreign direct investment, the legitimate interest tools of the European Union, and the equivalents under national law, public interest tools, as we would call them in the UK. And thirdly, finally, we look at updating the law, some more radical approaches. We're throwing out ideas for discussion. Just to mention two of those, we suggest that one might have a new climate and sustainability criterion. This could be taken into account as part of the efficiency assessment, could be part of the substantive competition assessment, or perhaps more neatly by building on the Article 21(4) of the merger regulation by placing an obligation on the European Commission to assess the impact of a deal, a merger, on climate change and sustainability. And the other thing that we look at in particular is the possibility of changing the burden and perhaps the standard of proof. But this raises all sorts of difficult questions. For whom should the burden be changed? What should the standard be? And perhaps most difficult of all, what should the parties have to prove? So I concluded with 3 points today. We must ground our analysis in the twin realities of climate change and the growing evidence of corporate power and harms which that is causing. Secondly, we can't just stand aside and vaguely as a competition community and hope that somebody else will deal with the problem, whether that's regulation, naked competition or whatever. And thirdly, we recognise that competition policy can only do so much. But where it can do something, I believe we have a moral and often a legal duty to use the tools available.